I want to tell you about the court case that will topple Roe v. Wade and end legal abortion. I want to explain why the case that would do that in the past was controversial, but that the case that can do it now is not so much. I want to explain why it was necessary before 2004 for me to analyze a controversial criminal defense in order to talk about how to challenge Roe v. Wade. But since 2004, it has been possible for pro-lifers to mount a much less controversial and much more successful challenge to abortion's alleged legality. April 1st, 2004 is when federal law legally recognized all unborn babies as human beings. Roe v. Wade had said babies who are recognizably human are persons. Then, abortion's alleged legality must collapse. In other words, 9 years ago, federal law said precisely what Roe v. Wade said must be said for legal abortion to end. But now, no court can legally recognize that new legal reality until a case is brought to it that turns on whether indeed that 2004 law has triggered Roe's collapse. For some reason, pro-lifers have not brought such a case in the past 9 years. Before 2004, the only kind of court case that could challenge Roe v. Wade was very controversial because someone had to break the law and be brought into court before he had any legal standing to talk about the only defense with the power to trigger the collapse of legal abortion. That defense was called the necessity defense. Before anyone could present that defense in any court, someone had to interrupt abortion. After 2004, it became possible to bring a court case that would challenge Roe without breaking any law. There are two ways to bring such a case. Now, the strongest way is for a state legislature to outlaw abortion enough that the law will be challenged in court. And then it will be the state's attorney general who will defend the law in court. In order to challenge Roe, the attorney general would need to argue that the 2004 law triggered Roe's collapse, which not only frees the state to restrict abortion, but obligates the state under the 14th Amendment to protect the life of the unborn, just as Roe pointed out that they would have to do. The 2004 law I'm talking about is 18 U.S.C. 1841 D, paragraph D. It's called the Unborn Victims of Violence Act. Let me give you a bit more detail about how it triggered the collapse of abortion's alleged legality. It defines all unborn babies at all stages of development as members of the species Homo sapiens, in other words, as human beings. Thus, federal law in 2004 established the legally recognized fact that all unborn babies are human beings. Roe v. Wade had said babies who are recognizably human are persons under the 14th Amendment. Roe also said, if the fact should ever be established that unborn babies are human, then of course the case for legal abortion must collapse. Similar personhood language is found in a few state laws. It could be argued that a state law can't be the basis for national policy where the laws of other states differ, but federal law is a policy for the nation. Federal law does not change from state to state. Often, state and federal laws have separate jurisdictions. In fact, the penalties of the Unborn Victims of Violence Act apply only on federal property. But paragraph D legally recognizes a fact about who is a human being. But facts don't change, especially facts like that, according to which section of law you are reading or whether you are reading federal or state law. And the fact which paragraph D legally recognizes is undisputed by any legal authority. The fact is affirmed by several states' laws, by many governors and presidents in official proclamations, and by dissenting Supreme Court judges. But no legal authority anywhere has disputed that fact. No legal authority has dared to allege that unborn babies are not human beings. The U.S. Supreme Court has to conform its rulings to federal law up until such point as it rules a law unconstitutional. But in the case of the Unborn Victims of Violence Act and similar acts in many states, these laws have been challenged in court many times and without exception have been ruled by state Supreme Courts and by the U.S. Supreme Court as constitutional. In other words, federal law in 2004 said precisely what Roe v. Wade said must be said for abortion's dubious legality to collapse. Roe even said that not only would states be free to outlaw abortion at that point, but they would be forced to outlaw abortion because the 14th Amendment requires states to protect the right to life of all unborn of all human beings. In other words, any state legislature has been able since 2004 to outlaw abortion as if Roe never existed. When the law is challenged in court against abortion, the state could explain the 2004 law to explain its obligation to outlaw abortion. Courts would then be forced to squarely address Roe's collapse. Once any court is forced to address Roe's collapse under the 2004 law, that court will be forced to rule that legal abortion is over. 40 years of infanticide have ended. There simply is no way around this legal reality. The only way courts can continue to pretend abortion is legal is for pro-lifers to continue declining to bring them a case that forces them to squarely address its collapse. So why haven't pro-lifers marched through this door of opportunity which God has opened for these past 9 years? For the same reason the people of Israel at the borders of the Promised Land picked up stones to stone Moses, Aaron, Joshua, and Caleb so they could choose a new leader to lead them back to slavery in Egypt. The impulse to shoot your own foot is strong in human beings. Very strong. How is it possible for human beings to so powerfully resist the very answer to their prayers to which their lives are dedicated? I can't explain it, but anyone can observe it. Consider heaven. What can be more desirable? Who could be uninterested in it? Yet see how little interest it inspires, and in fact how many say and mean that they prefer hell. If you are interested in proof that that is the human tendency at work here, all you need to do is compare the 2004 law with proposed future personhood laws. Pro-lifers promise in fundraising letters to this day that their proposed future personhood laws will trigger Roe's collapse clause when passed, bringing the end of legal abortion. But they deny that the 2004 law, which we already have, will trigger anything. We need to say the same thing again in 2014. I challenge you to find any significant legal difference between the 2004 law and proposed future personhood laws. And then I challenge you to look for their legal reasoning, explaining why the 2004 personhood language can't trigger Roe's collapse, but a 2014 law that says almost the same thing will. If you find any such explanation, will you forward it to me? I haven't been able to find it. For a complete explanation of the 2004 law and the opportunity it created to save the unborn, see www.saltshaker.us/SLIC, that stands for Stop Legal Infanticide by Christmas, SLIC, /NoGreenerLight.pdf. There is a second way to bring a case to court without breaking any laws that forces judges to squarely address Roe's Collapse Clause, and the second way does not require a legislature to do anything. The second way is for a grandparent of an aborted child to sue Planned Parenthood and the individual abortionist for wrongful death and deprivation of the companionship of the grandchild. You can look up how wrongful death works in Wikipedia. The ideal plaintiff would involve a mother who agrees to assert her own diminished culpability because she was deceived maybe by sex education classes, who could also then be named as defendants, and was pressured. For example, she was pressured by a boyfriend or by other adults. Ideally, to make this believable, she would also be considered considerably underage, and the boyfriend considerably older, and Planned Parenthood facilitated not reporting the statutory rape. Such a case would be much weaker strategically than a challenge to state law for three reasons. One, it is easy for judges to dismiss a lawsuit even when they are not heavily prejudiced against the issue, as most judges are against any challenge to abortion. To even the odds, a good state to try a case like this in might be Alabama, with Chief Justice Roy Moore on the bench. I would love to see that. Two, the case would be argued by attorneys who, in a lawsuit, a lawsuit would be argued by attorneys who are much less influential and who have far fewer resources than a state's attorney general would have, who would be defending a challenge to a law. C, number three, the third reason that a lawsuit would be a weaker case than a challenge to a state law is a lawsuit would stir far less public education. It's much easier for judges to get away with irrational rulings in cases which the public is not watching. But if a state legislature would put the 18 U.S.C. 1841 paragraph D argument in its findings of fact or in an accompanying resolution, public discussion of the measure would explode from the beginning. News reporters would call up law professors to explain why the abortion restriction could never challenge Roe, and the law professors might deny it, but they would never be able to defend their denial with anything approaching an explanation. Pro-life groups, talk show hosts, letters to the editor would educate the public about the emptiness of the denials until the big state newspapers would have to admit that Roe's collapse really was triggered in 2004. This process would cause every conceivable counter-argument to be put forward by newspapers in their desperate effort to save abortion's reputation. And every time a counter-argument would come out, that would create the occasion for pro-lifers, talk show hosts to supply the public with strong answers to every one of those objections, so that by the time judges rule, there is nothing left for them to say in abortion support that the whole population would not immediately recognize as unlawful and irrational. And I want to explain throughout the process how many times there would be time for a news story. The very introduction of a bill would that would challenge abortion and that would explain why abortion has already legally collapsed. That would be newsworthy. That would be a news story right there. When the bill passes out of a subcommittee, that would be a news story. It would be astounding to find 3 state lawmakers that would agree that that is the truth. And then when it gets out of committee, it would be a bigger news story. When it comes out of the chamber, goes to the other chamber, there would be a bigger news story. Tremendous opportunity for the public to become informed about this. And to understand that a ruling saying that this law is unconstitutional would be not only soaked in blood, but unlawful and irrational. To the extent the public understands that such a ruling would be unlawful and irrational, besides soaked in blood, the public will vote those judges out of office. At the state level, in the case of federal judges, the public will be ready to support Congress in taking measures against those judges, measures like those proposed by Newt Gingrich in a document called Bringing the Courts Back Under the Constitution. Several intelligent, constitutional, effective steps that citizens, through their Congress, can take to bridle out-of-control, irrational, lawless judges at the federal level, including the U.S. Supreme Court. And this is a document bringing the courts back under the Constitution that is found that he prepared in his 2012 campaign for president, and the draft I read was dated October 7th, 2011. There is no judicial abuse that the people do not have the power and constitutional authority to correct. But it does take a public so well informed that they are not snowed or intimidated by somber faces atop black robes. I am more controversial than you need to be to accomplish more than I can, because I began talking about how criminal defense could challenge Roe when a criminal case was the only kind of case that could.